Pacific Gas and Electric, or PG&E, has submitted a license renewal application, or LRA, to continue operating Units 2 and 3 at the Diablo Canyon Nuclear Power Plant in Avila Beach, California, for another 20 years after their current license expiration dates of November 2, 2024 and November 26, 2025, respectively. The Atomic Energy Act and the Nuclear Regulatory Commission's regulations provide an opportunity for interested stakeholders, which include members of the public interest groups and organizations, and other government entities, to seek a hearing to challenge renewal of a nuclear operating license. The essence of such a hearing is to adjudicate health and safety, environmental, and common defense and security concerns raised by the license renewal application. But before such a hearing occurs, the interested stakeholder must establish that they have standing to challenge the license renewal application and that they've included in their petition an admissible contention, which means essentially that the stakeholder has identified something material that is incorrect in the license renewal application, or something material that should be in the LRA but is not. The oral argument today will address these two things. 3 nonprofit groups have filed a joint petition to intervene and oppose PG&E's application. San Luis Obispo Mothers for Peace, who I will refer to as Mothers for Peace, Friends of the Earth, who I will refer to as Friends, and Environmental Working Group, who I will refer to as Group. Collectively, we'll refer to them as petitioners, jointly raised 3 contentions challenging certain aspects of PG&E's license renewal application. We'll get into the specifics of each contention later in the oral argument. We do note that the California Energy Commission has filed a request to participate in this proceeding as a party, but as a non-party, it did not submit any proposed contentions. One thing that we would like to stress is that the board does not work for or with the Nuclear Regulatory Commission staff in reviewing license renewal applications. This board is charged with determining independently whether petitioners have standing and whether the contentions they have submitted are admissible. Before we turn to questions on standing and contention admissibility, I'm going to ask counsel to introduce themselves, any co-counsel, and their clients. As this is being broadcast by way of listen-only phone line and webcast, I ask that counsel remain seated and use the microphone so that you can be picked up. Counsel for petitioners, would you please identify yourself and your co-counsel and your clients?
Good afternoon. My name is Diane Curran. I represent San Luis Obispo Mothers for Peace, and I will be speaking on behalf of the 3 petitioners, Friends of the Earth, Environmental Working Group, and Mothers for Peace. With me today at counsel table to my left is Caroline Leary, who's General Counsel to Environmental Working Group. I just want to mention to the board that Ms. Leary has to leave at 2:45, and so she'll bow out, but I'll be the one doing the talking, so it shouldn't affect anything. To my right is Dr. Peter Bird, our seismic expert. And directly behind me is Dr. Digby McDonald, who, when we get to contention 2, Dr. McDonald will come up and sit next to me.
You'll be playing musical chairs.
We'll be playing musical chairs, and he's going to be assisted by his wife. She's also a scientist, but not on this case, and her name is Myrna Urquibi McDonald.
All right.
Thank you.
Thank you. And counsel for PG&E, please introduce yourself, co-counsel, and your client.
Thank you, Your Honor. Ryan Leidy with Morgan, Lewis, and Bacchius, appearing on behalf of Pacific Gas and Electric Company. Joining me at counsel table today is my partner, Timothy Matthews, also with Morgan Lewis. And behind us in the gallery are individuals from Pacific Gas and Electric Company, Maureen Zawalik, Tom Jones, Jeff Bachhuber, Jennifer Post, Philippe Sunan, and Gerald Strickland, as well as Brian Hall from Westinghouse.
All right. Thank you, counsel. Counsel for staff, please introduce yourself, any co-counsel, and your client.
Good afternoon, Your Honor. This is Jeremy Wicca, counsel for the NRC staff. I'm joined by co-counsel Ian Murphy, and in the audience are various staff members, including Brian Harris, Kim Conway, An Yi, Jeffrey Rickoff, and a couple others, Your Honor.
All right, thank you very much. As we now move into the argument portion of today's proceedings, please, I'd like to let all counsel and clients and client representatives know the board has in fact read all of the pleadings that have been submitted. We are prepared to ask questions to ensure that we have a fulsome grasp of the arguments that are being advanced by each participant so that we can make an appropriate decision on standing and contention admissibility. We do not intend this to take the form of an appellate argument where each side gets a certain allotted amount of time. Instead, we plan to ask questions of various counsel on specific issues as we go through each of the contentions. We do plan to provide time at the end of each contention for counsel to address any particular issues they believe need to be addressed that we have not covered in the questioning. But please know we also intend to provide 5 minutes to each counsel at the end of the argument for a closing or summary argument. We also will, as we will start with counsel for counsel for petitioners, we will provide you with some rebuttal time as well after PG&E and the staff counsel have provided their summary. As I noted earlier, the purpose of the oral argument is to address whether petitioners have standing and whether they have included in the petition at least one admissible contention. We turn now to the question of standing. The board has an independent obligation to ensure that at least one petitioner has standing. The three petitioners here, as we understand it, all are organizations seeking to establish representational standing. Is that correct, Ms. Curran? Yes. Now, Mr. Wahutka, we understand the staff does not oppose standing of any three of the petitioners. Is that a correct understanding?
That's correct, Your Honor. And Ian Murphy will be discussing standing in contention 3 for the NRC staff.
All right. Thank you, Mr. Murphy.
Sure.
Mr. Leidy, as we understand it, PG&E does not oppose standing of Mothers for Peace or Friends, but does oppose the standing of group, both representational standing as well as its request in the alternative for discretionary intervention. Is that correct?
Yes, that's correct, Your Honor.
Okay. We've received and reviewed the submissions and believe that there are 3 areas of significance as it relates to standing that we'd like to address, 2 of which we have flagged for everyone in our order scheduling oral argument. The first of those is the issue of membership. As you all know, Group noted on page 5 of its petition that it is not a membership organization, but that it does represent the interest of its supporters. Group also contends in its submission that it satisfies the representational standing set forth in the United States Supreme Court decision, Students for Fair Admissions, Inc. versus President and Fellows of Harvard College. Ms. Curran, in reading that case, though, it seems to me that the organization before the Supreme Court there was one with members who specifically were identified, meaning that if that case is going to be of any help, it's going to be by way of application of the Hunt case described by the Supreme Court. Is that your understanding as well?
We think that the Hunt case was decided in the 70s, and the students' case basically clarified that what is meant by member or supporter they're kind of interchangeable terms, and there's some basic indicia. One is, does the member on whose standing the group standing is based support the group financially? Does the group have a purpose that relates to the interest of this member or supporter? Does the group communicate with the member or supporter, let them know what they're doing? And does the member or supporter have a reasonable chance to affect what the group does? And we've demonstrated that's true for environmental group, a working group. I think it was true for the student organization. So what I think the Supreme Court was saying there was, you don't have to have a membership organization in the traditional sense where you vote the board of directors in and out, and that's how you control the outcome of the decisions the organization makes. There's other ways to provide input to affect the direction of the organization.
Okay. And I agree with you. The Supreme Court in the Hunt case essentially boiled down its analysis to indicia of membership. And there it identified 3 of those specifically. That all of the growers and dealers in Hunt did 3 things. 1, they elected the members to the commission. 2, they financed the commission's activities. And 3, they were the only ones who served on the commission. Knowing or hearing that you've identified a couple others, I'm more comfortable looking specifically at the 3 that the Supreme Court identified. And I didn't see those particular indicia identified in the petition or in Mr. Cook's declaration. And I'm wondering where those 3 indicia might be identified, specifically as it relates to the members or the growers and dealers alone supporting the financial activities of the organization. Here in the reply, it seems as though only 61% of the organization's finances come from its supporters. So there would be financial support coming from somebody other than the supporters. So I'm just wondering if you can help me or point to me where we can find evidence or facts to support that indicia for Environmental Working Group.
Well, in our reply at page 3, we state that Linda Parks, who's one of the supporters who's authorized EWG to represent her, is one of EWG's financial supporters. Now, the fact that EWG gets support from other sources doesn't, I think the important thing is that the majority of their support comes from supporters like Ms. Parks.
Okay.
And then in terms of communication, I think it's described in Mr. Cook's declaration that EWG communicates regularly with its supporters, and let me just find the exact statement. In paragraph 3, he says EWG sends out monthly emails, uses the emails to keep their supporters informed of the status of legal proceedings in which their interests are represented. And in the hearing request, it represents the interests of its members. And the other members who wrote stated that they asked EWG, for instance, in paragraph 1 of Patricia Colin's declaration, EWG regularly asks about supporters' concerns and opinions, in order to guide it in establishing organizational goals. I am pleased with EWG's work and believe EWG generally represents my interests and I think that's the same statement in each of the EWG members or supporters' declarations.
Okay.
And did you have another factor that you wanted to?
I was just looking at the three factors that were identified by the Supreme Court in the Harvard case. Does counsel for PG&E wish to weigh in at all on that particular issue?
Yes, Your Honor. I think what we just heard is that the first mention of any of EWG's supporters being a financial supporter came in the reply pleading. As the Commission has noted, including recently in CLI-20-7, quote, "Our precedent explains it is not acceptable in NRC practice for a petitioner to claim standing based on vague assertions, and when that fails, to attempt to repair the defective pleading with fresh details at a later juncture." And that's exactly what EWG has done here by trying to supply information regarding the indicia of membership in its reply pleading. And so for that reason, we think that's improper as a matter of law.
Counsel for the staff, I know you haven't opposed environmental working groups standing, but I wanted to offer the opportunity for you to weigh in if you so chose.
Yes, Your Honor. In terms of the Hunt's three factors which you've identified, I think the only additional thing to note, so NRC staff agrees with the position taken by the petitioners, and I would point out that in terms of the financial support factor, Hunt, didn't establish a set number or a set amount of financing that has to be provided by its members or supporters, and so I think that's an important factor here. It is a good point that PGD makes that they didn't, provide financial information in that initial declaration. However, just looking to the Students for Fair Admissions case in general, and looking at the facts and the structure of that organization, there's a lot of analogies that I think you can draw between the two organizations, group and also Students for Fair Admissions. And so in that case, just to refresh the memory, so, the 4 members being represented were 4 high school students who had been denied admission. They had filed declarations stating they had voluntarily joined the organization. Here we have declarations from supporters stating they support group. They supported its mission, which we also have here. They received updates about the status of the case from the organization's president, which we also have here. And also they had an opportunity for input and direction on the organization's case and were being represented in good faith. And so just comparing the two organizations, that's where the staff sees a lot of similarities. And so for that reason, that's why the staff agrees with the petitioner's position.
Okay, thank you.
And Your Honor, if we could briefly go back to the germaneness element, I'm not sure if you were going to speak to that separately or if you wanted to talk about that now.
That was going to be the next element.
Okay, very
Before
good.
we go back to that, I'm sorry to interrupt, but I just want to finish on this question of whether we added a significant amount of information on a reply and shouldn't have done that.
Sure, I was actually, that was the next thing on my list to come back to you to ask about that, because as I understand some commission precedent in the Georgia Tech research reactor case, the commission actually will allow for supplemental declarations to be filed. And what I was going to request, Ms. Curran, is if you, by Friday, May 31st of this year, have a supplemental declaration submitted for Ms. Parks that attests to her financial support for Environmental Working Group, so that we have that in the record, that would be appreciated.
Will do. Thank you.
Thanks. Now, and I appreciate the case that you cited, Mr. Leidy, and we'll take a look at that. I'm not indicating any prejudgment of this particular issue, but just so that we've got everything we need or may need in front of us, we're asking that that be submitted. Now, relatedly on this issue of environmental working groups standing, in our order scheduling oral argument, we had asked council to be prepared to talk about a 1982 licensing board decision that essentially equated supporters or financial supporters with members. And it seems as though, based on the reply and the representation of Ms. Curran, that there is in fact at least one of the declarants who is a financial supporter. Mr. Leidy, I'd like to turn to you and give you the opportunity to address this particular issue from PG&E's perspective, essentially the rationale applied in that 1982 licensing board decision, which seems to be fairly on point to the case that we have before us today.
Sure. Thank you, Your Honor. So in LBP 82-25, the Indian Point case, the board used essentially a three-pronged test to determine whether a supporter could be the equivalent of a member. The first condition was that the sponsors must have indicated a desire to be represented by the organization, and that condition appears to be satisfied here. But the other two do not. The second condition was the financial support condition, and as I mentioned, we think that was untimely submitted. It was information that should have been included in the petition. I'm not certain about the Georgia Tech Research Reactor case that you may be referring to. It may be a licensing board decision that is rather old, and I would note again, CLI 20-7 is a commission decision, fairly recent, and so I would encourage the board to take a look at that. But I think perhaps the most important of the three conditions is the last one. And it provides that a non-membership organization must have, quote, a well-defined purpose which is germane to the proceedings. But that condition isn't satisfied here. In Indian Point, the licensing board found the condition was satisfied as to the Union of Concerned Scientists, or UCS, because, quote, the organizational objectives of UCS in regard to nuclear power are clearly defined and well advertised, end quote. But the board contrasted that with the circumstance in Health Research Group versus Kennedy, in which Public Citizen did not satisfy the germaneness condition. And as the licensing board explained, Public Citizen is an umbrella public interest group. It had wide-ranging objectives. It allocated funding to a diverse set of consumer advocacy interests, and that's exactly the case here. We need only look to the group's website to see that it is far more similar to Public Citizen than to UCS. The page titled Our Mission mentions many topics from sunscreen to pesticides. It discusses chemical safety and agricultural laws. It provides links to a tap water database and a cosmetic database. But it does not even once mention anything related to nuclear power. Unlike UCS, its objective in regard to nuclear power is not well defined. And if we look at another page on the website titled Funding and Reports under the heading of Where Your Donations Go, we can see that group devotes its funding to a diverse range of consumer advocacy areas, from toxics to food and agriculture. Only 8% of its budget is devoted to energy, and it is unclear what small fraction of that may be devoted to nuclear power. So in paragraph 2 of the standing declaration of Group President Ken Cook, he admits that EWG engages in policy advocacy on, quote, a broad range of issues, and explains that EWG's work on energy matters is focused on rate design and access to solar. So at bottom, Group is an umbrella public interest group, much more like Public Citizen, and it does not satisfy the third condition of the Indian Point test. And for that reason, we believe it doesn't qualify for representational standing.
Okay, thank you. Before we get to counsel for petitioner, counsel for staff, would you care to address the issue of the 1982 licensing board decision at all?
Yes, Your Honor. The staff's position is that despite having a very broad purpose, admittedly, group, that does not preclude group from the purpose of group being germane to this proceeding. That is all, Your Honor.
Okay, Thank you. Ms. Curran, would petitioners care to respond to the arguments advanced by Mr. Leidy on behalf of PG&E?
I'd just like to refer the board to Mr. Cook's declaration again, where he says that in paragraph 2, EWG is a 501c3 nonprofit, nonpartisan organization that works to empower people to live healthier lives in a healthier environment. And then reading down a little bit, it says EWG engages in research and policy advocacy on a broad range of issues related to state and federal energy policies, climate change, renewable energy, toxic chemicals, food and agriculture, water and air pollution, and public health. Certainly, radioactive contamination relates to public health and chemical contamination. This is a long-standing interest of Environmental Working Group. And I just want to point out that the cases that we found that reject hearing requests based on a broad statement of purpose, the ones that we looked at all related to an organization that sought to represent its own interests and not those of its members. And so the Palisades case cited by PG&E in opposing EWG's standing talked about how far away Palisades was from the city of Chicago, where this organization had its headquarters, and said, you just can't show us how this, it was, I think, a license transfer case, how is that going to affect this organization in Chicago?
Well, I think to be fair to PG&E, they were citing that, and correct me if I'm wrong, they were citing that in response to what they thought was Environmental Working Group seeking organizational standing or standing on its own behalf, not necessarily addressing the germaneness principle that we're talking about now. Do you have anything further?
Well, we did clarify that the terminology is we certainly did not intend to assert that EWG had standing all on its own without its supporters. We attached declarations from the supporters who authorized EWG to represent their interests in the proceeding.
Sure, and all due deference to our United States Supreme Court, they didn't make things easier with some of their precedent that kind of equates organizational and representational standing as the same thing. So, Mr. Leidy, I didn't want to step on your toes there, but if there's anything else you want to add.
Yeah, just one final point, Your Honor. I think when we're looking at germaneness and we look at the cases that the petitioners have cited, the SFFA and that case discussing the Hunt case. So SFFA was Students for Fair Admission. It was an organization seeking to represent students who were suing colleges over admissions policies. And the Hunt case was, it involved a state agency that represented apple growers and was seeking to represent apple growers in a case involving apple growing. Those two examples are directly on point for germaneness. The organization is clearly aligned with the individuals it's trying to represent. The delta that the licensing board was trying to point out in Indian Point in distinguishing public citizen was that it's an umbrella organization. It seeks to represent a whole bunch of things, and it doesn't have a clearly defined, singular purpose like SFFA or the Hunt case, and I think that's an important distinction.
Thank you. I think now we've addressed the first two of the issues regarding standing. I want to turn to the last one, which is group's alternative request for admission by way of discretionary intervention. We all know that the standard for discretionary intervention is in the regulations, and there are 6 elements that need to be addressed. We also, in our order scheduling the oral argument, requested that council be prepared to discuss those elements, especially in light of the fact that it is a joint petitioner here who raises no contention not already raised by another petitioner. Before we get into the specifics of that, I just ask, Mr. Leidy, does PG&E take the position that group did not address those 6 elements in its petition?
Group did not address all 6 of the elements. It did address a few of them in the petition in very terse conclusory sentences. But it did mention a couple of elements.
Now, I will agree with you that the manner in which it addressed them was succinct, let's put it that way. But as I took a look at the 6 elements in the regulations and compared them to the petition, I saw all 6 elements on page 6 being addressed. There were 2 bullet points and then a concluding paragraph. The first bullet point seemed to address 3, the second bullet point seemed to address 2, and then that concluding paragraph seemed to address the last of the 6 elements. If you, are you aware, sitting there, of which element you believe group did not address in its petition?
Well, I think regardless of trying to, connect the dots between the statements and the specific criteria, I think there's sort of a broader problem in that those statements don't support the criteria in the way that the Commission has envisioned that discretionary standing would work. And if you look at, our brief at page 16, where we're talking about, the element of, contributing to developing a sound record, a conclusory sentence doesn't really go to the point of showing that element is satisfying.
Sure, I get that part of PG&E's argument. The part that threw me a bit was where it said that group did not address all 6 of the elements, and I thought that it did, and so I wanted to give you the opportunity to point out to me which one PG&E thought was not addressed, so that I could make sure that we were actually taking a look at everything specifically.
Yes, I would say we did not see all 6 addressed in the petition itself, but I would have to go back and try to connect the dots to the 6.
All right. Moving on from that, we'll turn to you, Ms. Curran. My question to you is how are those 6 discretionary intervention elements met, especially in light of 3 different things? One being that group raises no contention other than those raised by 2 other capable organizations represented by capable counsel, including yourself, that it also has the ability to provide public comment on the draft SEIS, and 3, that it has joined in a request to the Commission raising what appears to be an identical seismic risk concern that's been referred for a 2206 proceeding. In light of those 3 things, how are those 6 discretionary intervention elements met by group?
Well, these issues that we're raising are at least the first 2 contentions are technical, complicated, and they have both extensive legal and factual components to them. It's quite an undertaking, and I really appreciate the compliment. But right now, there are 3 lawyers representing these 3 petitioners, plus we have 2 experts, and we are going up against a federal agency and a large corporation, which is very well financed, and it's something of a David and Goliath situation, and we think that our best chance of really doing a good job of creating a sound record and sound legal arguments would be to have a full complement of attorneys and experts working on this. whether EWG has experts that know something about seismic risks or the integrity of the Unit 1 pressure vessel, these are people who can help us evaluate arguments, evaluate testimony, help us phrase it in a way that people can understand it. Ms. Leary is an excellent lawyer and is a huge help to the other two lawyers on this case. I'm sorry that Hallie Templeton couldn't be here today. She's on leave right now. But this is a big undertaking, and the fact that EWG doesn't have any contentions of its own actually contributes to the efficiency of their participation. They're not going to be adding anything in particular. They're going to be helping the other two parties to do the best possible job of presenting the issues that we all agree are important. And I just want to add that in the Pebble Springs decision, the commission did give the licensing board discretion to consider what are the particular features of each case and consider how their discretion might be best applied.
Okay, thank you. Mr. Leidy, would you care to respond?
Yes, Your Honor, I've had a chance to look at the 6 criteria again, and I can articulate the ones that aren't addressed on page 6 of the petition. So if we look at the first bullet, the first sentence alleges that EWG would contribute to the development of a sound record. That's the first criterion, and it is addressed. But the next two, so the nature of the petitioner's property, financial, or other interests. In the first bullet, after the semicolon, it talks about the property, financial, and public health and safety environmental interests of its supporters, not the organization itself. And so we contend that it hasn't addressed that. It's seeking discretionary intervention as an organization. And so too with the third criterion of the possible effect of any decision. It doesn't talk about any effect of a decision in this proceeding on groups' interests, and it doesn't say what those interests are. It speaks only of its supporters' interest. And then finally, I think the third factor that weighs against discretionary intervention hasn't been addressed at all, about inappropriately broadening the scope of the proceeding.
Okay. And not to leave you out, but counsel for the staff, do you have anything to add on the last issue as it relates to standing?
Yes, Your Honor. And so the issue of discretionary standing, the staff agrees with PG&E's position. And so looking at the 6 factors, it does appear that they articulate at least one thing for each of the 6 factors. However, just going factor by factor, so the first extent, may originally be expected to assist. And so they articulate that group has expertise in public health and environmental experience in California. However, they don't tie that to the proposed contentions at issue here, none of which is one of those 2 areas of expertise, allegedly. And also looking at the availability of other means, and so as identified, the 2 other groups are jointly filing the same petitions identified by group. Council points out that it would increase efficiency. However, that's not one of the factors that you find in 2.309, and so that's not one of the things identified specifically for the decision maker to consider. And let's see. And that is all, Your Honor.
Okay, thank you. And Ms. Curran, we'll come back to you. As you have the burden on this, we'll give you the final word to anything that has been addressed by Mr. Leidy or, I am so sorry, I've forgotten your last name.
Murphy, Your Honor.
Murphy, I apologize. Mr. Murphy, if you'd care to address anything there.
Yeah, a couple points. First of all, in terms of the nature and extent of the petitioner's property, financial, or other interests, that's discussed in the standing declarations of the members, and I think it's pretty straightforward that this group is involved at the behest of its supporters in order to protect their interests in a safe and healthful environment. If the Diablo Canyon license is extended on the terms that are being proposed now, they're concerned about their health and safety. That the organization's interests are also the interests of their members. And second, on the issue of what I meant by efficiency, I was thinking of that last criterion, that whether the petitioner's participation will inappropriately broaden or delay the proceeding. The scope of these contentions is going to be determined by what's pled here. Unless some new information comes up that warrants amendment of our contentions, that certainly wouldn't be the doing of environmental working group all by itself. It would be some agreement by the petitioners that some additional issue ought to be raised or ought to be amended. It still is true that the expertise of environmental working group, including Ms. Leary's expertise, will help us to do a better job, will help us to meet your deadlines on time, because there's more of us to work on them. It's going to result in a better hearing record. And finally, in terms of the availability of other means to protect petitioners' interest, it just seems so obvious to us that there isn't any other venue for challenging this license renewal application that has real legal meaning, because the commenting on the draft EIS is responding to those comments is it's not something that we can ever appeal to the U.S. Court of Appeals. We have to go through the hearing process in order to get judicial accountability for the NRC staff's decisions on whether they adequately reviewed comments on an EIS. The only venue that is, the only road to the U.S. Court of Appeals is through this hearing process. Otherwise, it's within the staff's discretion to completely disregard our comments. And a 2206 petition is even more so. That is well established to be entirely within the discretion of the agency. And to appeal it is extraordinarily difficult. You have to meet some very, very high standard that basically the agency has completely run off the rails. So as far as we, in our experience of the NRC and the federal judicial system, this is it. This is the proceeding. This is the only place where any group can address deficiencies in the license renewal application and get relief where there's some ability to hold the agency accountable.
Thank you. Before we move on from standing, do either of my...
Yes, I have a question for Mr. Leidy. What practical difference do you see in the proceeding depending upon if group participates as an admitted intervener or if group participates only on an informal advisory capacity to the two intervening groups? What's the practical difference?
Your Honor, I see no practical difference in whether the group participates at all. That there are three contentions, and they are being advocated by other groups, so there really is no delta.
Thank you.
Any other questions?
Can I answer that question?
Oh, sure.
Thank you. I think it's really important for environmental working group, if they are going to be involved in this proceeding, they want to be a party, and they want to be able to be included in any appeal to the federal courts. So if they are reduced to the capacity of an informal advisor, that's not going to be possible for them, and they want to participate in this in order to protect the interests of their members.
Just to follow up on that, it strikes me that if there was a sincere effort or a sincere desire for them to protect the interests of their members, and they had a choice between assisting you informally and not doing anything, wouldn't they opt to assist you informally?
That's We haven't gotten to that point, but we're really, we think this is the right moment to be advocating for maximum participation. We really don't want to have to address that question. And it's partly because this group wants to be able to say to its members, we really advocated for you. We participated in this proceeding, and if we need to, we're going to take it to federal court. That's our commitment to our members and supporters.
Trustee Corus, any questions? Thank you. Before we move off the standing issue, as I noted earlier, at the end of each discrete section, we would provide council with a very brief opportunity to address anything that you believe we've not addressed, keeping in mind that we are going to give you some time at the end for closing arguments. I'll start over here with Ms. Curran and go to my left. Do you have anything additional on standing that you'd like to address briefly now?
No, we don't, thanks.
Mr. Leidy?
Nothing further, Your Honor.
And Mr. Murphy?
Nothing further, Your Honor.
All right, great, thank you. Before we get into the specific issues of contention admissibility, I want to ask a question to all counsel, but I'm going to turn over here, whether it's to Mr. Wahutka or Mr. Murphy, I'm not sure who. As you all know, on Thursday of last week, the NRC commissioners voted to adopt a new final rule that will govern both initial license renewal proceedings, like this one here, and the first subsequent license renewal proceedings. That approval included a revised generic environmental impact statement, or GEIS, and an updated table B1. Among other things, the updated GEIS in the table expanded the number of environmental issues to be considered on a specific plant basis or subject to a Category 2 review. Recognizing that the new rule is not going to go into effect until 30 days after it's published in the Federal Register, and I have no idea when that's going to happen, so it could be before we issue our decision here. Is there any impact that any of the council see on this proceeding due to the adoption of that new final rule? And if so, what is that impact? I don't want us to go halfway down the road and then we find out that there's an impact and we've all got to turn around and restart. So I'll start over here with counsel for staff if you'd like to address that, and then we'll move to the right.
Yes, Your Honor. The NRC staff's understanding of petitioners' arguments with regard to environmental issues is that they point to pages 4-61 and 4-62 of the environmental report. And those pages discuss the environmental issues of design basis accidents and severe accidents. And the staff's understanding of the 2024 GEIS and the proposed revisions to the relevant rule is that both of those are remaining as small impacts. So design basis accidents right now under the NRC's rules have a small generic impact. And for severe accidents, the rule also says that the impacts of those at all plants are small. And so for both of those, we think that a challenge to them right now is a challenge to the NRC's rules, which is impermissible, and would also be an impermissible challenge to the rules following this rulemaking as well. The other issue that petitioners bring up is they point to Appendix G of the environmental report, which has to do with severe accident mitigation alternatives analysis. And the rule now and the rule as it will happen will also say that a SAM analysis is required one time for the first license renewal and is not required for future license renewals. So we think nothing will change as a result of the proposed rulemaking, Your Honor.
Okay, thank you. Mr. Leidy?
Thank you, Your Honor. I think even at a higher level, there's really no change here. Once the rule is published and becomes effective, there is still a one-year compliance window that will extend far into the future. But for our current purposes, PG&E elected to prepare its environmental report under the current regulations as are required, and so those are the regulations that govern the sufficiency and adequacy of the environmental report now and going forward.
Okay. Ms. Curran?
Thank you. The new GEIS would affect only contention 1. And we are aware, and it's certainly been true, that the Commission's regulations before, under the previous rule, previous GEIS, in Table B1, the environmental impacts of accidents, including severe accidents, were considered Category 1. I think there was an exception made for severe accident mitigation alternatives, but my understanding of that rule was, with respect to the actual impacts of severe accidents, the NRC intended to codify them as small. And that hasn't changed. It also doesn't affect the legal basis for contention 1 being within the scope of this license renewal proceeding, which is Chairman Hansen's statement to Senator Padilla that's documented in our hearing request, that seismic issues would be reviewed in the license renewal proceeding. And we take that to mean the broadest possible interpretation, safety, environmental impacts. This was something said by the chairman on behalf of the whole commission to Senator Padilla, and we're relying on that.
All right. Thank you, counsel, for that. And I apologize that we didn't alert you in advance, but given the recency of it and the fact that we're here today, there wasn't sufficient time to get something out. So turning to the issue of contention admissibility, petitioners raised 3 contentions in their petition, and we're going to take them in the order that they've raised them. The first contention is, as we read it, related to seismic risk. Now, we read contention 1 as raising both safety and environmental contentions regarding seismic risk. Ms. Curran, would you please tell us, A, are we correct that there's a safety and an environmental component? And if so, what is the safety aspect contention, and what is or are the environmental aspect contention or contentions?
Okay, in a nutshell?
Well,
maybe I'll start with a nutshell and then
Sure.
move on from there.
yeah.
There is a safety and an environmental component to the contention.
Okay.
The safety component is that the risk of a severe seismic accident is unacceptable at Diablo Canyon. As a matter of fact, we think this applies not just to the license renewal term, but currently there is a significant risk that the PG&E has significantly underestimated seismic core damage frequency. And this is supported by Dr. Bird's declaration. And it's that seismic core damage frequency estimate that also undergirds the finding in the environmental report that the environmental impacts of external events, of seismic external events, are small. So it's a dual contention, they're related.
All right, so just so I make sure I understand, the safety aspect deals with the risk of severe seismic accident is unacceptable based on Dr. Bird's analysis. And the environmental aspect of that relates to the view that PG&E included in its submission that the impacts would be small versus what the petitioners claim based on Dr. Bird should be large.
Yes, that's correct. And just, and I think this is included in our petition, that Dr. Bird is an independent scientist. He doesn't say what we tell him to say. He studied this issue and he came up with these probability numbers. And we looked at them and said, this is serious. This is something that under NRC guidelines raises red flags for current operation. That was why simultaneously with the hearing request, we filed an emergency enforcement petition. We filed it with the commissioners and they referred it to the staff.
Sure.
But this, so in other words, if a safety risk is so significant that it puts it into the category of we must consider emergency actions under our safety regime, it automatically, necessarily means an environmental risk that is significant.
Understood. And so I just want to make sure that I understand and that the board understands what the scope of that environmental contention or environmental aspect is. And it's just as it relates to the impacts, and we'll get into the substance of this, but just so that we understand what the general high-level assertion is. Based on Dr. Bird's analysis, the impacts of a severe earthquake would be large rather than the small that's characterized in the environmental report submitted by PG&E.
That's correct. And by impacts, we mean both the potential for earthquakes and the consequences of earthquakes.
Okay. All right. And do you want to address well, let me ask this question, then I'll turn it over to Judge Tricouris, who has a question or two. In a footnote in the petition, there was a reference to SAMA, and PG&E and the staff raised an issue that if there was a SAMA contention, it was vague, and in the reply, there was nothing from the petitioners indicating that, yes, there was a SAMA contention. Is there a SAMA contention that's being raised here?
No, in the sense that our understanding of the concept of SAMAs in the NRC's generic environmental impact statement in the rule is that the NRC starts with a finding that environmental impacts of severe accidents are small. All accidents are small. And then the question is, if they're small, are there marginal improvements that will be cost justified? And we disagree with that basic premise that the impacts are small. So it's premature to start talking about SAMAs. We have to start with this finding of no significant impact, which ordinarily would be insulated from challenge, but is no longer insulated by virtue of the chairman's statement.
Okay. All right. Judge Tricouris, do you want to ask your?
Yeah. Well, I'd like to start out with a big picture question as well. Primarily to Ms. Curran initially. In footnote 12 of your statement of the contention, you do indicate that the risk is current and ongoing. Those are your words. My question is, if the risk is current and ongoing, and a petition has been filed with the commission in that regard, then how does this proceeding, or how does this issue fit into this license renewal proceeding?
It doesn't fit under the standard rules that have been in effect since 1991. It is true that the seismic risk here is not unique to the license renewal term. That is the rationale for the NRC refusing to consider, say, design issues in the license renewal term. But that's not what the chairman said to Senator Padilla. He said, we are going to look at updated information in the course of our license renewal review. I'm paraphrasing, I don't have the quote in front of me, but that's saying we're going to do something different for Diablo Canyon. And that's what we're resting on.
So you're saying, if I can summarize, that apart from the words of Commissioner Hansen, the issues we're discussing here with respect to seismic risk really do not belong in a license renewal proceeding?
Yes, that's right. Which is why it's so important. And why this is just a very unusual situation here. these reactors were going to close. The first one was going to close this year, the second one next year. And then there was a decision to reverse that. And the legislature wanted to be sure and had PG&E do an updated seismic assessment. Then Chairman Hansen says we're going to look at the updated seismic information in the course of our license renewal review. We want to get the benefit of that from the NRC.
All right. All right, I'm going to proceed with a couple of additional questions, and so we can move forward. Again, in the statement of the contention, you say that that the plant should be basically shut down until the risk of an earthquake-related core damage accident can be significantly reduced. What do you mean by that? How does one significantly reduce the risk of an earthquake?
Well, we're assuming that there are modifications that could be made to the plant that would anticipate the significant degree of shaking that would occur in an earthquake.
All right, so you're referring to SAMA.
Or design upgrades.
That is the purpose of SAMA with respect to not only seismic risk, but to all risk, all severe accident risk.
Well, just
Other
of
than
course,
SAMA,
I would just differ with you a little bit on that, in the sense that with SAMAs, you start with the assumption that the plant is safe, and you're adding some marginal improvements to make it safer. But that's not the situation here. The plant isn't safe. And so we're talking about, we're not at SAMA. SAMA is kind of those marginal beneficial things that if it makes sense to spend the money, let's make it safer, but we know it's adequately protected now. We're saying to you that we have evidence this plant is not it's not adequately protected now. There is a risk of a serious earthquake, and the risk is much higher than the acceptable level.
well, I'd still like to understand what you mean when you say modifications and what context those modifications are in. I can understand them within the realm of SAMA, because SAMA's purpose is to come up with modifications that would reduce the risk of the severe accident earthquake. And specifically, there are SAMAs that have core cooling, containment cooling, spent fuel cooling, alternate power, all of that, that's seismically protected, that would mitigate pretty much any earthquake, albeit they do cost a significant amount of money. But when you refer to modifications, you're referring to some other category of modifications, and I don't know where they would come from, or the impetus to implement those modifications would come from.
The impetus would come from the Atomic Energy Act, and the requirement to provide adequate protection to public health and safety using necessary measures, and that necessary measures are not subject to cost-benefit analysis. They're imposed because the NRC considers them to be essential to provide a minimum level of protection to public health and safety. That's why there were complaints that our contention was a mix of Atomic Energy Act and NEPA, and that is correct. But I think that the way the NRC applies NEPA to accidents is, first of all, in two ways. One is to say, if the plants are adequately protected, if the design's adequate, if the plant complies with the regulations, adequate protection gives us the equivalent, more or less, of no significant impact of any kind. And then there's a potential for a beyond design basis accident, but it's so small that we don't have to do anything more than look at some cost beneficial ways to reduce it a little more. But the Atomic Energy Act really, the other part of the Atomic Energy Act that, I guess going back to that idea that no significant impacts is something the NRC finds where it can find that there is adequate protection. And we don't think the NRC has got a basis to find adequate protection here because PG&E is underestimating the risk of a serious seismic core damage accident.
So in essence, you're, if I understand you correctly, you're trying to divest the, what I would call the probability weighted consequences aspect of the environmental analysis, namely SAMA, to basically make the modification without consideration of that at all.
Oh, I guess.
Is that what I hear?
I'm not 100% sure I understand your question, but I think, let me say something that maybe answers your question, that we think Dr. Bird's work shows that the risk of a serious seismic accident and, causing core damage is at an unacceptable level from the standpoint of the Atomic Energy Act. That has to be addressed first.
All right. By the way, I wasn't asking a question. I was simply asking for a clarification of what you had said. So I think the clarification I wanted, I think I got. That basically you're saying there should be no consideration to risk in this, well, there should be no consideration to probability in terms of this particular seismic risk because the risk is so exceedingly high and the probability is so exceedingly high that therefore it should be considered as almost a given event, that this earthquake would be almost considered as a given event with respect to plant safety, and therefore modifications should be made immediately or the plant should be shut down.
Yeah, I don't see how probability, I don't think we're taking probability out of that. We're just saying the probability is unacceptably high.
Right, which I think I said that. If I didn't, I
You used the
shouldn't.
word divest.
Yeah.
You said something divest of
Well,
probability.
What I'm trying to understand is to what extent you're separating yourself from SAMA, and it sounds like you're separating yourself from SAMA entirely, which means that anything associated with probability-weighted consequences are gone. Your assertion seems to be that the probability of severe damage is just simply exceedingly high and unacceptable, and therefore should be dealt with immediately.
Yes.
Should I go on?
If you've got more, go
Yeah.
right ahead. I've got some questions as well, but if you want to finish up, that's fine.
I'll ask one more. And then,
Sure.
all right. The seismic risk that's being, or the seismic the event probability that's being discussed here is a large earthquake analogous to the Noto Peninsula earthquake. And the number that has been identified is if I remember correctly, 1.4 times 10 to the minus 3. Now, I see that as an initiating event probability. Is that correct? nothing more than that, just an initiating event probability? Or do you see it as more than that? You see it as a core damage frequency?
Well, we're giving you an estimate of seismic core damage frequency, yes. That is the terminology that is used in Dr. Bird's declaration.
Right. But in Dr. Bird's analysis, just following through it, he's calculating the likelihood of that event occurring. And that results in 1.4 times 10 to the minus 3.
Yes.
Right. So implicit in that, if that becomes a core damage frequency, then implicit in that is the assumption that the likelihood of severe core damage from that particular initiating event has a probability of 1.
That was an approximation. It requires much more study by a full team, full SSC.
That was an approximation. It requires, to be more precise, it requires a full study by a team, an SSC team, and I think Dr. Bird said that in his declaration.
Approximation of a probability of 1. Okay. So in other words, what you're saying is that all of the discussion that's in your pleading regarding the comparison of that number, 1.4 times 10 to the minus 3, to various regulations and that deal with this sort of thing, which are relating to core damage frequency, and in some cases total core damage frequency. You're basically saying that we should treat that number, 1.4 times 10 to the minus 3, as a seismic core damage frequency that can be compared to those regulations.
Yes.
Okay. Go ahead.
Before I get back to...
Yeah, I'll take a simple one. Mr. Leidy, somewhere around page 461, I think, in the ER, you say that the environmental impacts of severe accidents are small. Now, is this based upon your analysis, or is this based upon the table B1 entry that says environmental impacts are small?
That comes directly from the Table B1 entry codified in the NRC's regulations and backed up by the GEIS.
Okay, can that be challenged in a litigation of this sort?
It cannot.
Without a waiver?
Without a waiver, which the petitioners here didn't request or receive.
And the safety aspect of this contention, that's part of the current licensing basis, is it not?
That's correct, and I think we heard counsel for petitioners acknowledge that as well. And I would also note that her discussion of seeking modifications to systems, structures, and components, that's the definition of a backfit. And if you look at the regulations at 50.109, the definition is there. And 50.109A5 says that the commission shall always require backfitting, regardless of any type of a cost-benefit analysis, if there's an adequate protection issue, and that's dealt with through the 2206 process. It is certainly part of the current licensing base.
Okay, thank you. Let me ask staff, do you agree that neither the current licensing basis or the Table B1 entry can be challenged here?
That's correct, Your Honor. The regulation says, quote, the probability weighted consequences of atmospheric releases, fallout onto open bodies of water, releases to groundwater, and societal and economic impacts from severe accidents are small for all plants. And that is what the environmental report is referring to in the pages that are cited by petitioners, and that cannot be challenged without a waiver to the rule.
Okay. Now, my question for you is, we do have rules, regulations, and they're developed through a fairly rigorous rulemaking process in which the staff develops them. They go through rigorous review. They are sent out to the public for review. They get comments. They answer the comments. And then eventually the commission votes on them and passes them. My question is, how do comments of one commissioner in response to a senator's question toss all of that out the window?
It was a serious question from Senator Padilla. What is the NRC going to do to reassure us about seismic safety at Diablo Canyon? And the chairman, who was sitting in the hearing with the other commissioners, said, we will look at the updated information in the license renewal process. Now, it raises a question, or actually, it shouldn't have to raise a question. What did that mean? We think we should be able to rely on the statement that the commissioner, on behalf of the commission, meant what he said, and that this assurance was something that was, on record for not only the senator, but the entire Congress and the senator's constituents. So whatever, Chairman Hansen didn't say, oh, too bad, our rules preclude us from doing any of this thing, you're on your own. He didn't say that. He said, we're going to take it up. That's what we're here to talk about.
Mr. Leidy, do you have any comments on that?
I am aware of no legal authority that suggests that a single comment at a congressional testimony, at a congressional hearing, could simply eviscerate codified law. There's quite good U.S. Supreme Court precedent, Perez v. Mortgage Bankers, that says, the APA mandates that if you're going to modify or revoke a rule, you have to use the same method that you use to promulgate that rule. There's no citation to any authority for anything that would contradict what the Supreme Court has said on this issue.
Can I comment?
Judge Arnold, I would just say I wouldn't characterize what the chairman said as a comment. It was a commitment. And if the board thinks that the chairman didn't have the authority to make that commitment, we would ask the board to refer this issue to the commissioners so they could clarify what did they mean.
Well, I'd just like to confirm one thing, to the staff council. Is it true that as we speak, the commission's staff is reviewing a petition, a safety petition from the petitioners to shut the plant down, and that they've identified a petition review board, and that board is working on this subject?
Yes, Your Honor. The NRC staff's position here is that there seems to be a fundamental misunderstanding of the scope of license renewal. The chairman, his statement was, quote, as part of the license renewal process, end quote. And the license renewal process, as laid out in 10 CFR Part 54 and in the NRC Statement of Considerations, is that all the issues that are unique to license renewal are subject to the licensing portion of that process. And then everything else, which is the current licensing basis and how the plant currently is, its current standards, is subject to the NRC's ongoing regulatory process. And so that's the portion of the license renewal process that we're talking about now, which is that at any time, any issue can come up that can challenge a current licensing basis, and the proper forum for that is the 10 CFR 2.206 request for enforcement action process. And these very same arguments that petitioner is bringing now, petitioner brought before the commission for both contentions 1 and contention 2, requesting to shut down the plant, and the commission recognized that this is something that's in the oversight space of the NRC's process, not the licensing portion, which is this proceeding. And so it was directed to the 2206 process. Both of those contentions are in the 2206 process right now. The experts and the staff with relevant knowledge are discussing it right now. as you said, there's a petition review board, and the end of that process will be a written product, and at any point in that process, which the commission directed it to, the commission has the discretion to intercede in that process. And so the petitioners are just trying to fit their arguments into the licensing section of license renewal, where they're really part of the staff's oversight in that process. And so the staff doesn't believe the commissioner's statement was necessarily inconsistent, because license renewal process involves oversight and it involves licensing. And at all times, including during the time that NRC staff is reviewing a license renewal application, they're always looking for new information that could affect the current licensing basis of the plant. And that's what the staff did after Fukushima Daiichi accident, which is discussed in the pleadings, and that's what the staff will continue to do. So our core issue is that this is not within the scope of this proceeding.
I'd just like to read the entire quotation from the chairman that appears on page 14 of our hearing request. He said, "We're going to be looking at updated safety information as part of that license renewal process. We did require all plants to take a look at the enhanced, to relook at their risks after Fukushima. Diablo, of course, did look at their seismic risk again, and we'll take another look at that as part of the license renewal process." So he used the phrase license renewal process twice. And I would respectfully submit there's a huge distinction between the license renewal process, which is a licensing decision. It's not discretionary. The NRC, it may have discretion in deciding whether the plant is providing adequate protection, but it's not, it's not a standard of, we'll take a look if we get around to it in the course of our oversight, where we have a lot of discretion to decide how much are we going to look at, when are we going to look at it, how important it is. This is talking about the license renewal process, which is a statutory process that has rights attached to it and obligations attached to it, way different from the general oversight of the current licensing basis.
But the only way that this issue can be the subject of a license renewal process is if we admit the contention.
That's right.
And then we would go through a adjudicatory hearing on the subject. Correct?
Correct.
And our deliberations with respect to admitting the contention are constrained by all of the rules and regulations that we have to meet.
Yes, Judge DeCoursey, that's true. And I would say you are also constrained by Chairman Hance's statement to Senator Padilla. That is an element that you must consider.
Can I jump in on that?
Please.
So I want to backtrack just a moment. We heard from Mr. Leidy where he cited the Perez versus Mortgage Bankers case. I didn't see in any of the submissions any authority one way or the other that the testimony of one commissioner or even the chair of a commission actually has binding effect on the scope of what the agency or the commission is supposed to do. I'm assuming Mr. Leidy, if asked, would rely on the Perez case. Do you, Ms. Curran, have any authority to cite to us that says we've got these parameters in the Code of Regulation, or the CFR, that says this is what a license renewal proceeding is supposed to look at? This is, if it falls within, then it's fair game. If it falls outside, we can't touch it. Do you have authority that says the chair's testimony before Congress is able to amend or alter or revise or supplement what's within those four corners?
I don't have a case, but it seems to me that in the Congress is the NRC's ultimate supervisor. The Congress passed the Atomic Energy Act the Congress engages in oversight of the agency. If the chair of the commission, in the presence of the other commissioners, makes a commitment to a U.S. senator to review a certain issue in a license renewal proceeding, then that has precedential value. It is something that the public should be able to rely on. And any determination by this body that it is ineffectual would in effect say that the chairman's word has no value. And we think that we would like the licensing board to rule that this commitment that the chairman made to Senator Padilla is something that on which you could base the admission of our contention. If you do not think that, we ask you to refer this question to the commission so that they can clarify for Senator Padilla and the public at large what was meant by this statement. Did it have no meaning? Was it just a comment as it's been characterized, or was it an actual commitment to address a significant safety concern that has been at the front of the public's mind with respect to Diablo Canyon for decades?
And I'll get back to you on what the actual scope or potential effect of Chair Hansen's testimony might be, but before I do, I want to turn to the staff. Do you want to weigh in at all on the issue of, is Chair Hansen's testimony before Congress, is that something that's binding that essentially would expand or include within the scope something that's not provided for, at least expressly in the regulations?
Your Honor, the NRC staff's position is that there would be no need to certify this as a question. The commission acts in directing the staff commensurate with its internal commission procedures. And those internal commission procedures direct how the staff as a collegial body can direct the commission as a collegial body can direct the staff to take actions. And so that's what the commission has to follow to direct the staff. And petitioners here have not pointed to that or shown how a single statement from the chair of the commission is one of those ways that are dictated by the internal commission procedures.
Now, getting back to you, Ms. Curran, on the testimony of Chair Hansen or the statement of Chair Hansen, you read it, but I want to take a look at it because I'm not sure, and I'm one of three folks up here, so, you know, this is just coming from me. I don't necessarily see, even if we give Chair Hansen's testimony the effect that you want us to give, that it is binding and it can expand the scope of our authority in license renewal proceedings. I don't know that it gets you where you need to go based on my reading of it, because he says we're going to be looking at updated safety information as part of that license renewal process. And then later on, we'll take another look at that as part of the license renewal process. Well, my understanding of the license renewal process set out in 10 CFR 54.4 says that the license renewal process will look at seismic issues, but as it relates to passive functions of structures and components. And so I don't see Chair Hansen's testimony as saying we're going to look at the effect of seismic on everything. I read it as him saying, yes, as part of our license renewal process, we look at seismic. But that license renewal process looks at the impact of seismic only on those passive structures and components. But what I understand petitioners to be asking us is to look at the effect of seismic on things well beyond those passive structures and components. So that's where, even if I were to agree with you, and I'm not saying that I do and I'm not saying that I don't, even if I were to agree with you that Chair Hansen's testimony can expand that, how do I read it other than saying, yes, this is what our license renewal process requires us to look at, and we're going to do that?
I think there's an implicit breadth to this review in the chairman's statement, One is he says, we're going to be looking at updated safety information. And I think it's reasonable to assume that what he means there is PG&E's updated safety review. And PG&E itself refers to this review in its opposition to our contention to say, we're doing a good job, we're looking at seismic risks. So he's saying, we're gonna have a look at this, and he also says that they're going to relook at, take another look at the risks of the risk analysis they did after the Fukushima accident. And that was broad. That wasn't just on passive components. It was on what is the seismic risk to this plant. So the implication, I do believe the implication of this is that this is going to be a broad review during the license renewal process.
Okay. So I was just going to give counsel for PG&E and the staff a chance to weigh in on that, and then we can turn to you.
Yeah, great. Yeah, thank you, Your Honor. I want to be very clear here. There's absolutely nothing in Chair Hansen's statement to the Senate committee that is inconsistent with the current license renewal process. The staff is looking at updated safety information in the context of aging management programs, in the context of severe accident impacts analyses. The problem is that petitioners didn't initiate the machinery to challenge those codified parts that are outside the scope of what you can challenge in a license renewal proceeding. The staff is looking at new and significant information related to external events for severe accidents, but that information isn't subject to challenge unless there's a waiver. So if petitioners really took Chair Hansen at his word and thought he was expanding the scope of the review, they could have initiated that machinery and they could have filed a waiver request. They didn't do that. And that's a key defect in what they're trying to do here, to challenge things that are codified, that are beyond the scope of the proceeding, and that they didn't seek a waiver from the rules to challenge. But everything that Chair Hansen said is correct. The staff is looking at updated safety information in those contexts. The petitioners just haven't followed the right process to challenge that.
Mr. Hutko?
Your Honor, I would add that also 10 CFR Part 54 talks about for current licensing basis issues that's subject to the Commission's or the NRC staff's ongoing regulatory process. So it's oversight role. And in its oversight role, at this very time, at the very same time that the staff is reviewing the license renewal application, the staff is also looking at the exact issues raised by petitioner in its 2206 process, and the staff is also always looking at new information, including the state of California is requiring, as has been discussed, an analysis, a reanalysis of seismic issues. And my understanding is the staff has that, and the staff is looking at that as well. So everything that petitioner is challenging here is consistent with 10 CFR Part 54, and the appropriate venue to make those arguments is the 2206 process, and that's where they are already. So there's nothing additional here for the board to rule on.
Ms. Kern, do you want to respond, and then I'll turn it over to Judge Trikoris.
I'd like to respond to Mr. Leidy's suggestion that we should have filed a waiver petition regarding Chairman Hansen's statement, and we did not think that was necessary because, in effect, Chairman Hansen did it for us. He made the representation. We don't need to ask that the regulations be waived. He said we're taking a different route with respect to Diablo Canyon. We took him at his word, and that's perfectly legitimate.
Judge Trikoris?
Yeah, well, the problem is that that the way that we conduct our deliberations follows certain rules, regulations, guidelines, procedures, and we do not have a choice in that matter. However, whatever decision we reach is subject to appeal, as you well know. That appeal goes to the commission. So, therefore, that is the process that that has to be followed. Now, my understanding is that when the commission evaluates the appeal, they will be using the appropriate rules, regulations, and guidelines that we should have followed to evaluate whether or not we did our job correctly. So there is a process, and it is being conducted right now. So it's just not clear to me what you're asking with respect to the comments of Commissioner Hanson with respect to the board's deliberations.
We'd simply ask that the board refer the issue to the commission, just to show that the board considers that there's an issue here that needs to be clarified by the commission.
Let's set aside or jump past this particular issue, and let's say, for argument's sake, we agree with you on the scope issue. We still have to address another element of contention admissibility, which is the specificity requirement. Petitioners have to reference a specific portion of the application that they're contesting and the supporting reasons for that contest. Where in the petition, as it relates to this seismic issue, do petitioners provide a reference to a specific part of the license renewal application that they're contesting? Because I looked for it and I didn't see it. So where, like I said, let's say we get past the scope element, we're now focusing the specificity element. How do petitioners meet that element?
I think there's 3 important points to make in response to this. First, we did refer to the seismic core damage frequency estimates in the environmental report. That's in Dr. Bird's declaration. It's really clear. So that he's definitely points to the seismic core damage frequency estimate, gives the page number in the environmental report, talks about where the number came from, previous iterations in earlier license renewal GISs. So from a NEPA standpoint, that's met. That requirement is met. From a safety standpoint, we have a little bit of a chicken and egg problem, that the regulations don't require the application to address seismic risks on the safety side. So you're going to look in vain for some discussion in the license renewal application about seismic risk. Dr. Bird focused on the 2018 seismic PRA, which is what the most recent seismic study that PG&E is relying on as input to the environmental report, and also in saying to the state that the plant is adequately safe. And perhaps, I don't know if the NRC has reviewed that in its ongoing review, but it may have been recognized as input to the environmental report.
So just so I'm clear, from on the safety aspect of contention one, you're saying the specificity or the specific portion is the 2018 seismic PRA?
Yes, and again, taking you back to the quotation from Chairman Hanson, he said, we're going to be looking at updated safety information. And that updated safety information is the seismic PRA. I think it's been updated more recently, but that's the... No, you have to say it to me.
Right. PG&E.
You may want to, yeah.
You may want to turn it off.
Push
Yeah.
the button at the bottom there. You'll have to hold it in while he's talking.
Got it.
PG&E is relying on the 2018 SPRA, as you said, but because of their updated seismic characterization, they use that 2018 SPRA to make a small adjustment to the seismic frequency, and that small adjustment does appear in the environmental report. So there is a mixture of 2018 and 2024 content in that number.
Okay, I'm going to just try to say this
Sure.
succinctly as I can. Dr. Bird is relying on the 2018 seismic PRA, which was updated to not a significant extent in 2024.
The SCDF was updated.
The SCDF, which is the seismic core damage frequency, was updated slightly in 2024.
Okay.
But this is the updated information that we believe Chairman Hansen was talking about would be reviewed. And under Union of Concerned Scientists, the case that we cited, Chairman Hansen is telling Senator Padilla, this is now relevant to our license renewal decision. We're going to look at it, and we're not going to approve this until we've taken a look. So that brings it into the ambit of the license renewal proceeding.
Mr. Leidy, do you want to address the specificity element as it relates to, and I think we're talking about, well, we've kind of merged them together, if you want to address it as it relates to the safety as well as the environmental aspect.
Sure, Your Honor. I think as to the safety element, as Ms. Kern noted, the regulations don't require that information to be in an application. But when you look at the contention admissibility criterion in 2.309 Foxtrot 1, Romanet 6, it says that an admissible contention, quote, must include references to the specific portions of the application that the petitioner disputes. It's not enough to dispute some other document somewhere else that's part of the current licensing. You must dispute something that's in the application. And as petitioners acknowledge, this information is not in the application because it's not required to be there, because it's not part of Part 54 or license renewal. And I think that's the fundamental issue with their safety challenge. I do agree that they have identified specific portions of the environmental matters that they wish to challenge. The problem there is they're identifying codified information that can't be challenged without a waiver.
Mr. Wilka?
Your Honor, the NRC staff agrees there's no genuine dispute on the safety side because there's not a single application. There's no genuine dispute on the environmental side because those references, as we discussed, are challenges to rules which are not inadmissible. And again, Your Honor, all of these arguments are before the staff experts under the 10 CFR 2.206 process. The staff has issued an initial assessment on that with responses due on May 29th. And any additional information can be added at that point, and that's where this additional information is supposed to go. This is all current licensing basis oversight issues, Your Honor. There's nothing more to it.
I've got a couple more issues or a couple more questions as it relates to the environmental aspect of contention 1, and then we'll take a brief break. Ms. Curran, as it relates to the environmental aspect of contention 1, are petitioners claiming that it's a change in the potential seismic hazard for Diablo Canyon that underlies the environmental aspect?
An underestimate, I would say. It didn't change. It was just, we think that Dr. Bird has a more reasonable estimate.
Now, as has been alluded to here a number of times, the main impediment that I see to the admissibility of contention 1 on the environmental side, setting aside the whole scope issue, is the small versus large and it being a category 1 or a codified issue, and there was no waiver petition that was filed here. I understand Dr. Bird's analysis. I understand your explanation of Dr. Bird's analysis that the thrust faults are stronger, and therefore when all of that is factored in, your view or petitioner's view is that the impact is not small but is in fact large. I understand all of that, but how do you get around, or how do you advocate that we somehow address and get around the fact that small is codified, and that's where that comes from. And there was no waiver petition that was filed.
We go back to Chairman Hansen's statement, that we rely entirely on that statement. That commitment, I should say.
Okay. Mr. Leidy, Mr. Wutka, if either of you have anything on that particular issue, I don't want to foreclose the possibility of allowing you time.
Nothing further, Your Honor.
Your Honor, the NRC staff understands that all the arguments in contention would have been conceded other than the statements of the commissioner. And as we stated, those aren't inconsistent with the 10 CFR Part 54 rulemaking. The commission directed these issues already to the staff under 10 CFR 2.206 process. And the NRC's internal commission procedures dictate how the commission acts. And I don't think this is one of the ways that the commission can direct the staff.
Judge Arnold, Judge Koukouras, any other questions on contention one?
I have one clarification right now.
Sure.
It's footnote 12, actually, of your petition. Again, I think I referred to that earlier as well. You're addressing this question of the small risk that has just been discussed in that footnote, and you say, therefore, but in terms of modifications, you then are referring to the SAMAs. You're saying, therefore, the severe accident mitigation alternatives listed in Appendix G of the environmental report are grossly inadequate to address the magnitude of the environmental impacts involved. So your way of dealing with this idea of the codified conclusion that the environmental impacts are small, you seem to be referring to the severe accident mitigation alternatives and saying that they're grossly inadequate. My first question would be, what do you mean by grossly inadequate?
What we mean by grossly inadequate is that the premise of the SAMAs is that PG&E is starting with small impacts. And so then if you're starting with small impacts, then the list of SAMAs is going to be marginal improvements to make something that's good better. And if you're dealing, as we think they should be, with large impacts, you're not talking about marginal improvements. You're talking about major alternatives such as not pursuing the action alternative. That's not traditionally looked at as a SAMA by the NRC. That's what we're trying to get at here, Judge Koukouras, is SAMAs are an animal that relates to small impacts. Let's make it a little better if it makes sense to spend the money. But that's not what we're talking about in this contention. We're talking about unacceptable level of risk that warrants major measures, A, to provide adequate protection, and B, to perhaps consider the alternative under NEPA of not going ahead with this. Not a good idea.
There is, as I mentioned earlier, I'll repeat it. There is at least one SAMA which would basically make the plant risk-free from earthquake. I think it's SAMA 19 of Appendix G. And it does that basically by assuring the core is cooled, the containment is cooled, the spent fuel pool is cooled, using a separate new equipment that's seismically qualified to be available after the earthquake of the magnitude we're discussing. So the plant is self-contained. The safety of the plant is just sort of self-contained under that, in that mode. This modification is extremely expensive. Well, I shouldn't say extremely expensive. By nuclear standards, it's not even moderately expensive, but it is certainly expensive. And it is subject to the requirements of being probability weighted. And you haven't made any representation regarding whether or not this new and significant probability information would perhaps bring that modification into the forefront if the SAMA were reanalyzed with this new information. So basically, I just want to confirm that you are not relying on the SAMA process in your contention. Your contention is, which would bring it under the realm of environmental information that is not subject to the Category 1.
Yeah, let me just play out what would, supposing we hadn't challenged the finding of insignificant impact or small impact, and we're saying, well, you really should have considered alternative SAMA number 19. Then I think the answer would have been, well, those impacts are small. It doesn't, and that's what the SAMA analysis says. Why would we spend all that money? The impacts are small. And our contention, the purpose of our contention is to say there's an elephant in the room. There's a really big problem here. And whatever array of SAMAs that have been created in order to mitigate this small risk, we're saying go back to the drawing board. The way you identify reasonable alternatives in a reasonable way is to make a good, fair assessment of the likelihood and consequences of an accident. So we think it's premature to start arguing about what SAMA might be cost effective when we don't have an adequate risk analysis that would lead to a reasonable array of SAMAs. The SAMAs that you would consider where the risk was significant would be really different from the array that you would consider if the impacts were small. And we're not going to nitpick the array of SAMAs for a small impact that appears in the environmental report. We're going back to the issue of, is the impact significant? And if we can prevail on that, then PG&E would have to go back and look at a new array of alternatives, maybe some things that would be considered necessary, worth the money. But we're really not there yet.
Anything else?
Thank you.
All right. As I mentioned at the beginning, I will offer to council, as we have, from our perspective, we have concluded contention 1. We'll give council opportunity, if you'd like, to provide any final or brief issues that you don't think that we addressed or that need to be addressed more, keeping in mind that you will have 5 minutes at the end for final closing arguments. Ms. Curran?
I would just like to say that Mothers for Peace was founded in the 1970s out of concern about earthquake risks to Diablo Canyon. They have consistently advocated for not building the plant, not operating the plant, and over more than 4 decades have constantly monitored the safety of the plant to do everything they could to ensure it would be as safe as possible. And even when the California legislature passed SB 846, providing PG&E with a loan, encouraging them to apply for license renewal, they didn't say, we're not worried about earthquake risks anymore. They said, we're going to require PG&E to update their seismic studies. And they put something in the bill that said if the NRC requires seismic improvements that cost too much money, we may change this decision, or the CPUC may change it. So that's, was in the thinking of the legislature. And now we have Senator Padilla asking Chairman Hansen, what are you going to do to protect my constituents in the event of an earthquake? We think this is hugely important, the commitment that Commissioner Hansen made to the senator, and this is on an issue that goes back the entire operating life of this plant and before. So please, we ask you to take that into account, that something significant was said here about a long-standing problem that is at the forefront of not only the legislature's concerns, but Senator Padilla's.
Thank you, Counsel. Mr. Leidy?
Thank you, Your Honor. I just wanted to briefly go back and tie up some loose ends on the last exchange we had between Judge Tricurros and Ms. Curran regarding SAMAs. And I just want to make clear for the record that the only mention of SAMAs in the petition is in that footnote 12 that's being discussed. A single sentence that, if I could paraphrase, says Appendix G is bad. That's not enough to demonstrate a genuine dispute for an admissible contention. The petitioners didn't identify SAMA 19 or any specific SAMAs. They didn't criticize any aspect of any of those SAMA analyses. They didn't allege that considering this new information would somehow overcome the cost-benefit analysis and cause a material change in the outcome of that analysis. Those are all things that you must do to demonstrate a material contention, and that has not even, not remotely been satisfied here in that single footnote.
Thank you, Counselor. Mr. Oaxaca?
Your Honor, as clarified by the petitioners, contention 1 comes down to a statement of Chair Hansen's, and as we have explained, the statement is not inconsistent with the NRC's license renewal rule, which specifies that aging management issues unique to aging management, are part of this licensing proceeding. All other issues related to the current licensing basis, including these seismic issues, are part of the NRC's oversight process. The NRC is at all times, including at the same time as reviewing license renewal applications, making itself aware in its oversight role of information that could impact the current licensing bases of its licensed facilities and acting on that information as appropriate. So the statement is correct, and the statement does not change the scope of this proceeding or the scope of the NRC's rules.
All right. Thank you, Counselor. It is 2:59 Eastern Time here in the East Coast for those folks joining from out in California, subtract 3. We're going to take about a 10-minute break, so let's meet back here in the hearing room at 10 minutes after 3 Eastern Time. Thank you.